Okay, in the matter of the People versus Travis Wiley, the record should show that Mr. Wiley and his counsel and Mr. Barnard on behalf of the people are all present. All 12 members of the jury are present. Juror number 51, I see you with papers. Are you the foreperson?
I am.
Would you please hand those papers to a bailiff who will in turn hand it to me? I'm going to ensure that the verdict form is... I guess I did not ask you, has the jury reached a verdict?
We have, Your Honor.
Okay. All right, I have examined that form. I'm going to hand it to the clerk and ask her to publish.
We, the jury, find the defendant, Travis Wiley, guilty of first-degree murder, signed by the foreperson and the 11 jurors.
Mr. Nelson, do you wish to have the jury polled?
I do.
Clerk?
I can't see all of it. Juror number 53, was this then and is this now your verdict?
Yes.
Juror number 5, was this then and is this now your verdict?
Yes.
Juror number 51, was this then and is this now your verdict?
Yes.
Juror number 9, was this then and is this now your verdict?
Yes.
Juror number 39, was this then and is this now your verdict?
Yes.
Juror 9, are you 9?
Yeah.
Okay.
Oh.
I said,
59.
no, I said, well, I didn't, I should have been 9.
I said yes.
Okay, you said yes, I'm
59.
sorry, I missed him. Okay, so I didn't hear you say yes, I'm sorry. Okay, so 59 said yes, so juror number 2, was this then and is this now your verdict?
Yes.
You skipped 59.
Juror 59, was this then and is this now your verdict?
Yes.
Juror 52, was this then and is this now your verdict?
Yes.
Juror number 3, was this then and is this now your verdict?
Yes.
Juror number 27, was this then and is this now your verdict?
Yes.
Juror number 8, was this then and is this now your verdict?
Yes.
Juror number 14, was this then and is this now your verdict?
Yes.
Okay, ladies and gentlemen, at this time, the court wishes to express its appreciation to each of you for your service in the case on behalf of Adams County. It's been said that other than military service, jury service is one of the highest duties of American citizenship. Trial by jury is the cornerstone of our system of justice, the connecting link between the courts and the people. It's one of the blessings of a free society. There's no more sacred public trust than to be chosen as a juror to try a cause, to sit in judgment on the acts of one's fellow man. The law, which is the court's duty to declare, is often found with comparative ease. But the facts of the case, which you as jurors are the exclusive judges, are nowhere written, are usually in dispute, and are found only after the jurors have determined the truth from the evidence. No case is easily decided. I make these remarks upon discharging you from further service in this case, not only in appreciation of your service here, but also to give due recognition to the exalted character of jury service in every case. You've been taken from your daily routines to perform this task this week. I thank you for your patience and your thoughtfulness throughout this process. You were told throughout your jury service that you were not to discuss this case with anyone. That no longer applies. But you have the right not to discuss your jury service or the case with anyone, if you so choose, or to choose to discuss the case, if that's your preference. I will make myself available in the jury room probably in 10 to 15 minutes. If you have any questions or wish to make any comments about the process, I would be interested to hear those. However, you're not in any way obligated to stay. I have some matters I need to attend to, so like I said, it'll probably be 10 to 15 minutes before I come in there. You may also be sent a survey to share your comments about your thoughts about the process. So at this time, you're hereby discharged. And again, I wish to thank you on behalf of Adams County for your service. So you may exit.
All rise.
Okay, you may all be seated. The record should reflect that the 12 members of the jury have all exited the courtroom. Counsel are still present, as is Mr. Wiley. Pursuant to statute, the court is hereby ordering that Mr. Wiley, now that he has been found to be guilty of the charge, that he be held without any pretrial release conditions pending sentencing. And we do need to set a sentencing hearing. The court will order that a pre-sentence investigation report be prepared. Do we know what the time frame? Okay. I need to take a very short break to get my calendar so that we can pick a date. Counsel, if you have your calendars, fine. If you don't, why don't you also retrieve them?
Thank you.
I'll be just a moment. Yeah, we will be in recess. I'll be right back.
Remain seated, come to order.
Okay, we're back on the record. The court has its calendar. I guess first question, counsel, is what block of time we need to set for the sentencing hearing?
Assume at the least, Judge, 2 hours to half a day.
So probably a half a day. Would you agree with that, Mr. Nelson?
Yes.
What is the, what's the lead time for probation to prepare?
I am not certain. I think it's,
I would guess, and it is an uneducated guess because of my
5, 6, 7, 8 weeks. 8 weeks.
8 weeks, that was gonna be my guess.
So we'd be looking at January.
Yes.
The court's schedule, and counsel, I don't know your individual schedules, but I'm looking at Thursday, January 25, or Friday, January 26.
Your Honor, given my logistical issues, I would prefer Friday, January 26th.
Okay. Could we set it in the morning?
You can. That's
Okay.
not a problem for me.
All right.
That's fine.
Could we set it at 9:30 on Friday morning, January 26?
Yes.
Yes.
And we will reserve the remainder of the morning. If we need to, we can continue in the afternoon. It's 9:30. And I'm setting that slightly later because of my travel that morning.
That's fine.
Um, Do you have an order?
I've prepared one, Judge.
Okay.
Mr. Nelson is reviewing.
Understand.
Can you step out for me, please?
Court is going to issue and enter judgment of guilty on the verdicts, or on the verdict, excuse me. Court has set a sentencing hearing for Friday, January 26th at 9:30 a.m. Court has ordered the preparation of a pre-sentence investigation report. The court does wish to make a record here on certain matters that arose in this case after deliberation began. As I indicated earlier, the jury was instructed and retired to deliberate at approximately 11:02 a.m. they were given exhibits and the court's instructions. The court received back from the jury at approximately 1 o'clock several questions. After conferring with counsel in the presence of Mr. Wiley, the court answered those questions, and there were 3 questions received at 1 o'clock. The court answered back each of those questions. At approximately 3:15 p.m., the court received another question. In response to that question, the court urged the jury to continue to deliberate, review the evidence, and the instructions. At approximately, and the court, by the way, prior to answering the second question that came at 3:45, the court again conferred with counsel in the presence of Mr. Wiley. And then again, shortly thereafter, at 3:49 p.m., the court received a series of perhaps 5 additional questions. The court again conferred with counsel in the presence of Mr. Wiley. The first, and in the court's judgment, the most urgent question concerned a possible mental or physical condition that one of the jurors may have been suffering from. The court inquired about that, and before the court received an answer to that question, the jury informed the bailiff that it had reached a verdict. And the jury then was brought into the courtroom and delivered its verdict. Again, for the last set of approximately 5 questions, the court, before answering, conferred with counsel in the presence of Mr. Wiley. And the court, in turn, asked a question of the jury. And before receiving that answer, the court was notified that the jury had reached a verdict. All of those questions and answers will be given to the clerk and will be made a part of the record in the case. The court just wished to make a record as that those circumstances a little bit unusual. Anything that either counsel would like to add to the court's record? I'll begin with Mr. Barnard.
No, Your Honor.
Mr. Nelson.
No.
Okay. Then at this time, Mr. Wiley will be remanded to the custody of Adams County, and the court will be adjourned.
Ladies and gentlemen, please rise. The session is adjourned.
So everybody knows I didn't do this.